Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So, without any further ado, I will turn to our speakers today for our program. It's my pleasure to introduce our moderator, Judge Feffer, who will then introduce our other panelists for this program. As a judge of the Los Angeles Superior Court for 13 years, Judge Feffer served in various roles, including an unlimited jurisdiction civil independent calendar court for 6 years, a civil trial court for 3 years, and family law court for 4 years. During that time, Judge Feffer presided over more than 75 civil jury trials, more than 500 civil bench trials, hundreds of evidentiary hearings, and numerous settlements conferences with a diverse range of complex factual and legal issues. Judge Feffer has handled a wide array of cases, including employment litigation, professional liability, personal injury, elder abuse, products liability, business litigation and partnership disputes, real estate litigation, land use litigation, eminent domain, insurance coverage, insurance bad faith, and entertainment cases. Now as a neutral mediator, arbitrator, and referee since 2020, she has an impressive track record of successful settlements across a broad spectrum of civil cases, reflecting her varied assignments on the bench and prior civil litigation practice representing both plaintiffs and defendants. Judge Feffer received her JD from the USC Gold School of Law, her MA from USC's Annenberg School of Communications, and her BA from UCLA. Go Bruins! Thanks so much, Judge Feffer, for putting together today's panel and for moderating for us. I will hand it over to you to introduce our other speakers.
Great. Thank you, Katie. Thanks so much. And I'm excited to introduce our 2 panelists. This kind of came about, we were at a conference a few months ago, and I had some questions about some GC issues that came up both during MSCs when I was on the bench and during mediations, and I was picking their brain. I thought, oh, this is a great subject. So I'm super thrilled to have both here. Each is a superstar in his own right. First, I want to introduce Mark LeHocky. He's a mediator and arbitrator with a nationwide complex dispute practice. He's affiliated with ADR Services, Inc. Mark previously served as a senior executive and public company general counsel to both Dreyer's Grand Ice Cream Incorporated and Ross Stores Incorporated, as well as part of the senior legal team at Nestle SA. Prior to his general counsel days, Mark spent 20 years litigating intellectual property, antitrust, commercial matters, class actions, and other complex disputes for clients, ranging from startups to Fortune 100 companies. Mark has repeatedly been named a best lawyer in America for mediation and was voted Mediation Attorney of the Year for the San Francisco area for both 2024 and 2022 through Best Lawyers Attorney Peer Rating System. Mark also teaches at UC Berkeley School of Law on the intersection of law, risk management, and decision-making. His new Berkeley Law course is entitled Managing Difficult Legal Conversations. Mark's full background and published articles are on his website, just www.marklehocky.com. And finally, Mark received his JD from Berkeley Law and his BA from UCLA when his daughters remind him it was much easier to get admitted. Oh, I beg to disagree with your daughters, Mark. So, next up, again, also a superstar in his own right, please introduce Edward J. Weiss. Ed is a highly accomplished attorney with over 30 years of diverse legal experience. Ed is renowned for his expertise in mediating and arbitrating disputes. Since 2021, Ed has committed his full attention to dispute resolution, also volunteering as a mediator for the Los Angeles Superior Court and for the United States District Court, Central District of California, and he's on their panel there. A former federal prosecutor, trial lawyer, and business leader, Ed has excelled in antitrust, business, employment, entertainment, consumer protections, intellectual property, real estate, and securities law. Ed's extensive background includes an 18-year tenure as general counsel for Ticketmaster, the last 11 of which he was general counsel or chief counsel. where he played a pivotal role in navigating complex litigation and safeguarding proprietary technology. Ed holds a JD from the University of California, Berkeley School of Law, and also an AB in political science from the same institution. So welcome, Ed and Mark. So first thing I think would be helpful to discuss and if interest is kind of understanding your audience. What are the different types of GCs and legal teams? Start off with Mark and then hear what Ed has to say. So as an initial matter, how do you think about the world of GCs and legal teams? Are there generalizations that are possible based on the people, their individual roles and backgrounds, the size or type of company? What are your thoughts, Mark?
So initially, thank you, and thank you to Katie Jones and ADR Services for putting this program on. It's an honor to join Ed and you in this conversation. So I think in some cases, it's normal human behavior. We all sort of look for patterns and we all look for things that we can generalize. When you're thinking about GCs, it's really hard to generalize. Now, certainly you can make some comments. If it's a very large company, it's a large legal department, the GC may be actively involved or delegating a lot of the work. That's worth figuring out early on. But when you think about the individual, whether it's the senior GC or maybe an intermediary, really important to figure out who that person is. If you're considering doing some work, making a pitch or something, do your homework. A lot of us, I'm sure Ed did too, and I did, we were sometimes out on the speaking circuit. We were talking about our ideas and our thoughts about what works and what doesn't. Look that up. Some of us have an orientation towards we want to get matters resolved as soon as possible. Others potentially want to take stronger, more aggressive stands. Please don't misinterpret my comment as saying I wasn't aggressive when we needed to be, but I was just much more selective about that and much more proactive about exploring alternatives. So do your homework. Don't make an assumption because this company is of this size and it does even the same kind of work as another company that your GC is going to have that same orientation. Understanding that, also understanding their background. Do they have a litigation background? If not, that you may approach your conversations differently with them. And even if there's an intermediate counsel, which often is the case, understanding their background as well is important. They may have had extensive litigation experience and been through both the good, bad, and the ugly. They may not have. And really understanding that up front helps you shape the work you're going to do and your recommendations, your advice in the most practical way.
Thank you. And Ed, and what are your thoughts on that?
Well, I agree with everything that Mark said, and it's an honor and a privilege to be on this panel with both of you. I appreciate this opportunity. There are obviously different types of general counsels and different compositions of legal departments, as Mark said, but there are also different types of lawyers. And the first thing that a good general counsel or litigation manager or in-house lawyer needs to do is select the right lawyer. There are a lot of excellent lawyers out there, but selecting the one for the type of case that you have is critical. You want to have someone that ideally has some type of familiarity or feel for your industry, some of the unique challenges that your business faces. And within each company, there's a diversity of types of cases. You want to have the right lawyer, you want to have the right horse for the right course. So that's the first thing that the in-house lawyer needs to do. And then the outside lawyer needs to understand and conform what they do to the in-house lawyer that they're working with. And it's a function of how complex and involved is the case that you're dealing with versus the level and type of experience that you're working with. And you have to basically just play it as it lays. If you have a very inexperienced in-house counsel, they may need more from you in terms of helping to communicate with management. And even the most inexperienced lawyer or in-house lawyer that might not have a litigation background can be an excellent and useful teammate and provide a lot of help to the outside counsel. And what you want to do is make sure you're getting the in-house counsel what he or she needs be effective and to navigate what they need to navigate inside their company. But also the in-house counsel is a great asset. So you want to figure out what that lawyer can provide and make sure that you're fully leveraging that. In terms of, I'm sorry, just in terms of information and familiarity about the company, maybe the transaction or the matter that's at issue in the case, or where they can go to help you find the information that you need inside the company or organization.
Okay, so Ed, obviously you came to the world of GCs and corporations with your public sector prosecutorial background, which is unusual and interesting. So is there any kind of pre-work that you would recommend to get hired and stay hired in the GC area?
The pre-work is to find out as much as you can about the company and perhaps their existing cases, how the company is viewed, and what the lay of the land is in that industry, so that when you come to the conversation, you can speak the in-house lawyer's language, or use the nomenclature of the industry, or the issues that are at hand in the case. Sometimes there are cases that have nothing to do with the industry, or they're not unique to the company, and that maybe it's not as important. But if you have something that is right within the wheelhouse of that company, or that's integral to that industry, you want to have some level of familiarity. It may not even be necessary or needed, but it will give the in-house lawyer who's selecting you and is going to be working with you a level of comfort that you're part of them, and have made the effort to familiarize yourself.
No, I think that's very insightful. And Mark, obviously you're giving a class, right now to law students. So what are your thoughts on
and frankly, the genesis of the class is the last 25 years of doing the ADR work and working with brilliant lawyers, and in many cases that go very well, very efficiently. And in a number of situations where, honestly, I use the example of, I feel like I'm an accident reconstruction expert, because I want to first figure out, how did we get to this point? And some of that is traceable back to failure to do some stuff up front early on, which, by the way, is not always obvious, but building off of Ed's comments, it's finding out, if you're the outside counsel and you want to do the work, what are the real objectives here? Now, sometimes you say, well, of course it's obvious, they just got sued, they need a defense of the case. But I mean, the objectives behind that, are they trying to resolve the matter as quickly as they can? Are they trying to make a statement by their response? Just about the statement part, but we'll go there today, but really trying to figure out what's behind it. And not just as to objectives about speed and all of that, but how big is this? And again, if you're an outside counsel, been there before, you're sometimes, but not enough information.
I believe we have a little bit of a glitch on Mark's side. Let me get in touch with him. One moment.
Okay. All right.
On a few occasions where we were fighting the battle, and it was good counsel, and there was a argument for what we were doing. But when you dig deeper, you go, well, actually, this is a segment of the business. It's very small. We're actually thinking about getting out of the segment, and that should be fleshed out right up front. As part of the objective conversation, because that can lead to a different path. And also some version of it's the principle. I will be a broken record on the reality that most of the time the principal argument is overused. If you really dig into it and ask good questions and say, show me the data that really being aggressive back is going to prevent other similar suits, because there's so many competent counsel on the defense side and the plaintiff side to pursue that case, regardless of how actively a company fought this one. Getting that background is how you help not just the client, the institution, but the individuals who are in the mix, including in-house counsel, GCs, who own that dispute as much as you outside counsel do.
Thank you. And so switching over to the area of mediation again, as judge doing MSCs and also as a mediator, oftentimes there'll be a corporate entity client, and I'll have the GC and also the outside, call that the outside retained for purposes of this litigation. And so from where you stood as the GC, each of you, how would you best prepare your GC or in-house client for successful mediation? What are some key steps you can take, et cetera? Mark, if you want to start off with that.
Sure. So again, going back to the issue of objectives, really understanding it so you, and if you're the neutral chair, can have the conversation back, and Ed knows this thoroughly, as do I, which is to help them understand what it really means to fight the matter. I know it sounds obvious, but again, it's not, because there are sometimes too much focus on the particular dollars arguments about this is really small, not worth more than X. And I think one thing Ed's seen, I know I've seen a lot, is what I call the organizational costs and the human costs of disputes going on. Now, again, there are certain disputes you can't compromise on. We had a few of those, but the majority of the time, I think there's a tendency, unless you've lived through some of these big ugly cases, as I litigated too, the client, the institution, even the executive team, may not fully appreciate what that toll is, how many people are going to get diverted, how much loss of focus there can be on this. So getting to that early on is helpful. The other thing that I think is absolutely key, and again, it's part of why I want to do this other work, is we have trended in the last couple of decades away from what I'll call active conversations with adversaries. We've moved away from that, starting when I was a young lawyer, to we fight over everything. We don't share information. We try to keep you from seeing ours and fight to get yours, as opposed to having direct conversations with adversaries. I mean, counsel to counsel, sometimes GC to GC, just to test what you think you know, test what you think they know, and finding out what sometimes are just simple factual gaps that can be straightened out. Now, the trend, again, I mention it because I think it's the wrong trend, away from doing that is we don't talk to the other side. We battle, we battle, we battle. Eventually, we'll bring in Ed or me, and then we'll start to sort it out. And that's frankly a really bad strategy. It's partly, I think, propelled by the fact that clients, some corporate executives, some GCs, really are angry or want to make a statement. And my response back is, let's figure out how good or bad everything is. Let's sort out what they know, and then we'll maybe recalibrate. Maybe we won't, but either way, we'll be better informed. So I'm a broken record. During my GC days, I actually had a rule for my teams inside and outside, says we're not going to mediation until we have not one, not two, but 3 conversations, lawyers to lawyers. First one, you will surprise them. Why are you calling me? Second one, they'll hopefully understand why you're having the conversation. And third one, you will be better informed, they will be better informed, and then you can have a more useful dialogue. And by the way, if it goes in that direction, you may not need to hire it. You may not need to hire me, hire you, Your Honor. You may be able to broker your own deal, but doing all that pre-work is essential. And I think part of our early job is to make sure our clients understand that's strategic. It's something you need to do.
Thank you, Mark. And then Ed, on your end, how would you prepare your client for mediation, especially since GC, you kind of see the overall picture of the company as opposed to this piece of litigation?
I think the first thing that has to happen is the in-house lawyer needs to prepare the lawyer, the outside lawyer, for what this case is and what it represents and what the objectives of the company are. At the earliest stage, the in-house lawyer and the outside lawyer need to get on the same page. So ultimately, you're going to want to educate the mediator about what your case is and what your objectives are and so forth. But before you can do that, you have to make sure that there's a common understanding between inside and outside counsel. And sometimes that's more challenging than it may seem. You could have a lawyer that this is their first case for the company. Perhaps it's outside counsel that's been appointed by an insurance company. This may be their first exposure to the company or the organization. It may be their last. They are not as familiar perhaps with the company and any unique things about it, and any wrinkles with this situation that may be new to them. So you need to make sure that you're doing that foundational work before you can go past go. And then in terms of getting ready for the mediation, I think it's really important for the in-house lawyer to be a good partner to the outside lawyer, and to make sure that all the information that they need is available to them. That could be a whole host of things. It could be enabling the outside lawyer to disabuse the mediator about things that are not accurately stated in the other side's brief. It could be making sure that the people that need to be aware of the mediation, that it's upcoming and it's going to be held on a certain date and what's involved, know about it far enough in advance so they can start formulating some views and give proper direction. It could be that you need certain people within the company to, in more complex cases perhaps, to help with with an alternative business solution to help resolve the case. You don't want to wait for the mediation to start finding the operational people at 3 p.m. when they may be in Europe, and already asleep. You want to make sure that you've done that in advance so that you have that at the ready when the time comes.
Whoops, sorry. Go ahead.
No, go ahead, Mark.
No, I'm building after you use the word advance. I think advance, like preparation, or the keywords here. When you're dealing with some groups, some companies, they may be a small executive team, maybe very small. The GC may be the only lawyer, but in other cases, you have layers of decision makers, or at least numbers of people that are part of the conversation, internal stakeholders as well. By the way, same concept applies if there's an insurance carrier someplace. You want the people that are going to make the decisions, or hopefully help you make the decisions, to be fully informed. So all the advance work Ed's talking about, that's why I was talking about the direct conversation on the other side. You need to make the best decisions. All the key decision makers need to be informed. They can't be informed to the last minute. They can't be informed the night before or the day of. That leads to a lot of difficult conversations, because people come into mediations following executive meetings saying, well, what's the case worth? They're between, 100 and 200. And then things develop at the mediation that show that's completely disproportionate to reality. And that leads to some unpleasant conversations later. Well, why did you say 100, 200? Or they say, well, we're not going to go outside of 100, 200 because the prep work wasn't done. So I always want to underline that, that key point. The prep work is as important to get to a successful mediation, and it depends upon the client really understanding risk and reward, kicking the tires really hard. And again, the direct conversation's part of it. Sorry, I didn't mean to interrupt otherwise.
No, those are excellent points. The other thing that needs to happen is the outside lawyer needs to help the in-house lawyer to prepare something in writing to explain the risks and rewards of the case, and to make sure that it's in the format that either the executive team or perhaps the in-house lawyer supervisor in the legal department, if you're not dealing directly with the GC, what that needs to look like so that it's the most helpful. Sending in a 40-page memo may not be the most effective way to do it. That probably won't, except in the rare case that's not even going to get read. You need to make sure that the key points are highlighted and understandable, and also can be communicated perhaps to other stakeholders, whether it's a parent company, shareholders, board of directors, other key constituencies, depending on the size of the case. And then another preparation item that is sometimes is more important than others, but it is important, is who is going to attend the mediation in addition to the in-house lawyer or the general counsel. It may just be the general counsel. It may just be the in-house lawyer. It may be an important decision maker on the business side, whether it's to hear what's going on, get some more information about the case, authorize a settlement, or perhaps be prepared on the spot to help orchestrate some type of alternative business solution that can be used to settle the case in addition to or instead of just the payment or the receipt of money.
We both raised some excellent points, and something I would see, fortunately, not too often, but again, doing MSCs on the bench and also mediations, it again, not that frequent an occurrence, but it does happen from time to time where it appears that the litigation counsel is more, I guess, amenable, shall we say, to the mediation process than the GC, who really just, we did nothing wrong. We shouldn't be here. This is a frivolous lawsuit. And there seems to be both lawyers for the same client are not really in accord. So how do you, is it the executive team of the company not on board with mediation? How would you handle those situations, Ed?
Well, I think the first thing to handle, and sometimes you may not be able to handle it, could be an intractable problem or disagreement. But I think to Mark's point about early preparation is that you need to try to determine what that is and make your best attempt to resolve that before showtime. You really don't want to go into, if you can avoid it, and again, sometimes you can't, but to the extent that you can resolve that satisfactorily before you get to the actual mediation, the better off you'll be. I also wanted to make one other point about preparation, if I could, in terms of who attends. Sometimes it's just as important who doesn't attend as who does attend. You can have some difficult personalities, and I've certainly seen my share of them over the years at Ticketmaster. I don't think I'm giving away any state secrets there for anyone that knows anything about the company. Sometimes my job back when I was either working on behalf of Ticketmaster as an outside lawyer, before I went to the U.S. Attorney's Office, or early in my years when I was the litigation manager for the company, was managing a very, let's say, strident, a bit in your face, kind of legendary CEO, and making sure that that person who himself liked to attend mediations because he was a lawyer and had a feel for the litigation process, he would attend himself. Probably the most helpful thing that I did was making sure that that CEO stayed in a separate room and wasn't in the either in a joint session or interacting with the other side, for which the other side I know was very grateful.
Well, and just
So, yeah, Mark, and what I would see this. We'll see this come up sometimes when there's, say, insurance counsel for the company versus the GC, and they're not in accord.
right.
What do you see in that regard?
Well, again, this goes back to the preparation issue and the importance of having direct conversations with the other side ahead of time, and making sure in the conversations between the outside counsel and inside counsel, the so-called client, what this process is for mediating. Process to see if we can reach some kind of agreement. And the default sometimes, and it may be the client that shows the executive, it may be the GC, it may be staff litigation counsel who are very excited about their case. But the reality is we're here to see if we can get something done. And all the invective and all the, we want to really tell them they're awful. Or by the way, tell Ed and I and you, those people are really awful. To me, politely, that's a lot of noise. The issue is, what can we do here today? If we're spending time on, it's their fault, we didn't mediate 3 months ago, or it's their fault, this didn't happen before today, we're not making progress. Also, if there's an effort to slander the other side or blame them, of course, what happens? The other side is going to respond in kind. So the key thing is, before any mediation, you're talking to the carrier, you're talking to the GC or the CEO, whoever shows up, to say, this is a different process. We're not going to win the mediation by vilifying the other side. We want to talk about things that they'll listen to, which relates to my other big bugaboo, and I think it's Ed's too. You send each side your brief. ahead of time. You don't just share the brief, you send it to them ahead of time, because the inside group needs to potentially reevaluate. Oh, by the way, for all the plaintiffs' attorneys that are dialed in here, this is what you need to do. I had a case a while back, I always remember it because I looked at the brief that came in, I looked at my calendar, and I said, I have it on my calendar, we're not meeting for 6 weeks. I called the plaintiff's attorney and said, Sebastian, do I have the calendar right? And he said, oh, no, you're right, but this case is different. And a very horrendous fact pattern. And because he knew his case was really strong, but there was a lot there to digest, he wanted to make sure the other side, the corporation and their carriers, had time to review that and understand this doesn't fit into this box. This is over here. So it gets back to the issue of preparing and talking to your client who may feel good in the moment, again, wanting to say bad things about the other side. If you really want to do it, if your client really if you, the outside counsel, think your client really has to bend, fine, go off in a separate room with a mediator. We'll listen to you then. Then let's get back to work. And I've had more than one person say, well, I'll share my brief, but I have to send you another letter where I vilify the other side because that's what my client wants me to do. I go, fine, I'll read it and I'll throw it away. So, part of it again goes back to if you're plaintiff's counsel and you feel like you have a compelling case, show them, allow time for them to digest it, not just the first person who reads it, but if it goes up the food chain and there's multiple constituents, to make sure they can really evaluate it so you can have productive dialogue. I've been there like you have, Your Honor, as has Ed, where the GC shows up and says exactly what you said. I don't even understand why I'm here. I've heard this is a BS case. Well, guess what? It's not a BS case. And they had not been prepared, not to their fault, but that's why you have those conversations and have them early. And please get your briefs in early. It's not just for Ed, me, and you. It's to have the other side reset expectations.
Right. Well, I just wanted to add briefly, if I could, that
Absolutely.
Well, the communication on your side is critical. It can be equally important to use the mediation process and the exchange of briefs process to educate the other side, the other side's GC, and to enable that person to properly educate their side of the case, their management, to help facilitate a settlement. This is your chance to give an unfiltered message to the other side. You probably don't want to do it laden with invective and ad hominem attacks. That's probably not useful. But if there are things about the case that especially if you're concerned that the message isn't getting through properly to the other side, it's a fantastic opportunity to make those points through the mediation process.
Well, sometimes the problem arises when, again, this may be a tip more for, I'll just say plaintiff's counsel opposing a company with the GC and outside counsel, or even, both of you sitting as a mediator, that as broadly as possible, the corporation is sued because they took the advice of the general counsel who's there in front of you in mediation, and you as mediator try to settle the case, and the client turns to the GC and says, we did this or we didn't do this on your advice. And the GC, well, of course, of course the GC is going to, why would we settle? Because you gave, so what, when you're opposing counsel dealing with that or the mediator, how do you navigate that situation?
Well, I think the first thing, presumably you'll figure this out early in the process, but you should go into the mediation with a plan for how to navigate or circumnavigate that, because you don't want to make your own client, your own in-house counsel client, feel uncomfortable. That's not going to lead to anything good. And then you also have to consider if the let's call it the problem is on the other side, how are you going to deal with that? You don't want to back someone into a corner. Maybe the person that gave the controversial advice or approved the business practice that went awry. If they're in the other room, you want to make sure that you're handling that in a way that is, is useful and constructive and not destructive. And just the most important thing, I think, is to have a plan for it in advance. That's something that's sensitive. You shouldn't be making those types of decisions on the fly.
And that's a reason, again, I'm obsessive about sharing your brief. If there's anything secret, backstory that you think is important, you don't want the other side to see, send a separate letter or pick up the phone and schedule a call with us. The more we understand the dynamic, besides the so-called facts and the alleged merits, the more we can help all of you. Your Honor's example is real. I'm not picking on GCs, but many, many times over the years where what surfaces at some point is part of the problem is the persons that have shown up, either authorized or themselves were involved in making the decision that led things to spin out of control. Not to pick on anybody, but we've been there before. So the key, so I was talking about, I think about this job on level 1 is accident reconstruction, but the level 2 is lifeguard. We need to try to save everybody. And that includes whoever maybe made the decision that turned out to not be the right one. But we don't do that by shining a light on, you really screwed up when you put this in the contract, didn't do that. So the reach out that counsel can make, plaintiff's counsel too, absolutely. If you think this is what's going on and this is a sticking point, I'd like to know that. Maybe, the other side may or may not acknowledge it, but that's more of the preparation work. So that in turn, you can do the better assessment of what you're up against. The internal client can figure that out. We're not here to shine lights on woulda, coulda, shoulda. But if we know those are some of the stumbling blocks. I had a case not too long ago, which of course can't go into detail, where I warned people it's going to go badly, but the decision maker in the room was the person who was unfortunately sort of triggered the event. And as I predicted what would happen, did happen, and it went from bad to worse. So the more upfront warning, and by the way, the upfront warning isn't the other side's a jerk. He's not a good lawyer. I'm a good lawyer. No. Tell me what you think the impediments are, and we'll try to come up with a strategy to work with that.
So this might be an occasion to mention something else that crossed my mind in this regard, which is especially when you're dealing with sensitive things like this, but not just in those situations, the outside lawyer needs to be as diplomatic as possible and use care when telling the in-house lawyer or the GC that they need to either accept less or maybe pay a lot more than what they're expecting. Because one thing that I think gets lost in the shuffle with the dealing with people in the corporate world is sometimes the in-house lawyer takes it very personally. What is going on with their company? They're very loyal to the company. They love their company. They think their company is the greatest. Not always the case, but this often can be the case. And when you're telling someone something that they don't want to hear, I'm not saying to not tell them something that they don't want to hear, because that's your job and you have to do that. But you just have to keep an eye on your, let's call it your bedside manner, because you'd want to make sure that the news that you're delivering is done in the most humane way, both because it's the right thing to do and because to not do that can have some unnecessarily bad repercussions for how things are going for the settlement discussions.
Yeah, and just to second that, so one of the things we spend time on in my class at Berkeley is the behavioral science that propels us all in the directions we go. And you've all heard the term confirmation bias. The longer you hear something that you like, the more you stick with it. So the early diagnosis that says, "Oh, we're in great shape, we're going to win, we can't lose," is something that we all do. We hold on to in our head, and we get ready a year or two later, $2 or $3 million litigation costs later, to have the conversation. What do you mean we might lose? What do you mean we're going to have to pay a large sum of money? You said. So this goes back to the preparation work. The mistakes that sometimes appear before me have to do with the misdiagnosis, potentially overselling, what I call overpromising and under-delivering phenomena. Good, well-intentioned counsel haven't kicked the tires thoroughly enough The client wants to hear early on, we're in great shape. What I always tell my outside counsel when I was GC is your job is to tell us when you think we're being stupid. Now, don't use that exact word, but that's really your job. As soon as you can sense we may have some problems, we want to know that right away so we can have what often has to be a staged conversation, meaning not false, but we thought early on it was this. Well, there seems to be some indication it's not quite that. Let's do some follow-up. Let's have another conversation. You move people. This is like Elizabeth Kubler-Ross is adjusting to grief events, catastrophic events. You need to help move decision makers. You don't do it in one conversation by saying, we thought we had a great position. Now we're telling you we've got a really questionable position. That's part of the preparation process and building to it. And not in an artificial way, but if you wait till the mediation or right before the mediation, do it. Yeah, welcome, get ready for the, the bad conversations. And my last comment there is, while we're talking about sort of optimizing the role of your outside counsel or plaintiff's counsel in the role of the mediator, the in-house counsel, the GCs have the responsibility to sort of demand this. Tell us early on what you think the problems are. Do what what people refer to sometimes as a pre-mortem. If we are having a conversation a year or two from now and saying, what the hell went wrong? How could that have happened? Go through that vigorous process earlier, because once that confirmation bias sets in, it can be pretty ugly later on.
To that point, Mark, the obligation and the necessity to brief management on where a case is going and what the risks are, it's not just the in-house counsel's responsibility. Even if the outside lawyer is briefing the in-house counsel, and especially with the bigger cases and the bigger exposure, you need to make sure that, without necessarily going over your in-house counsel representative's head, you need to make sure that the right people, all the right people in the company, know what's going on, especially if it's a serious exposure and the case might not be going the way they might think it is. So, and you want to help your in-house counsel partner to manage that communication flow and give them at all stages what they need to make sure that that's done timely and fully and correctly.
Yeah, and in-house counsel, GCs and staff counsel, for good reason, are responsible for running their group. And if you put budget projections in there about what it might cost, or you've given reports up to executive team and the board, you may get difficult conversations later. Well, wait a minute, you thought this was a nothing burger, or you thought this didn't even need to be reported. Prepare for that by doing all the prep work and having the dialogue. The other thing I did want to come back to, I want to come back for a minute. Ed mentioned the role of, having people in the mediation. I'm often find it humorous sometimes when I've got outside counsel in a session, inside counsel, but the inside counsel seem to understand that their role is to not say anything. And politely, I find a way at some point to say, now, this is your case, not just the lawyer's case. We want to make sure we end up with the best result, because if it doesn't go well, somebody's going to be looking at you and saying, but you said, but the positive part, not just the ownership of potential problems, but the positives are, if you're in-house counsel, Ed was alluding to before, you can have a speaking voice. It's not a simple Mutt and Jeff thing. You be the bad guy, I'll be the good guy. It is the opportunity to talk, sometimes across table, the other side. I always did when I could make sense of going, to tell the other side what we did and why we did it, or what they wanted us to do, why we didn't do it, in not insulting ways, but in common sense. This is either what we have to do or we can't make changes to it. And by the way, there's a really good reason for it. The jury's going to hear the really good reason if we don't settle the case. And by doing that, you humanize. You're part of an entity. If you're the other side, if you're the plaintiff's counsel, you should hear what they're going to say. You should invite those kind of conversations. You may agree, you may not agree, but at least you can better assess this rather than the typical process of we don't talk, they're evil or stupid or lazy. So that's why I think the in-house team can have a very useful role in that session, whether it's a joint session or just with the mediator. And
I'm sorry.
no,
I didn't mean to cut you off. It's not just a matter of giving the in-house counsel a role or just for show. The in-house counsel can be extremely useful and effective, especially when they know something more viscerally, perhaps, about this matter, where it fits into the grand scheme of things with the company. I had a mediation recently where there was a very experienced in-house counsel that was that had a deep litigation background, and at a certain point in the process, this was orchestrated, I think, quite effectively by the outside lawyer. They turned this person loose, who made a very strong statement about why their side was in the right. It wasn't just a matter of the arguments that they were making that were not materially different than the arguments that the outside lawyers were making quite effectively, but it was the strength and the conviction of those arguments that came through, and I think it was a useful way of leveraging the abilities of the in-house counsel. And that's something that outside counsel, especially those that think that, oh, they're hired to do this and it's been turned over to them. Your point about this being the company's case is absolutely true, and the outside lawyer should not lose sight of that, but also should use all the tools in the toolkit, one of which might be what the in-house counsel or the general counsel brings to the party. Use everything and consider using the in-house counsel.
Right. So what I've heard from both of you, it's variations on the same theme of preparation, communication with the client, whether you're the in-house GC, litigation counsel, managing expectations, and also being prepared to have difficult conversations. So kind of more along the lines of preparation for mediation. How important is it to select a mediator with GC experience? And then, since both of you are now neutrals, what do you see going wrong at mediations? So Ed, if you want to start off with that.
Well, I mean, obviously, I'm going to say it's important to consider selecting a former GC as a mediator. But I think the reason for that, number one, sometimes it's helpful that your mediator has some business experience, and number two, and along the lines of what we've been discussing today, is that the general counsel or the former general counsel is steeped in the ways of the way corporations work and or organizations work, and some of the internal traps for the unwary can be successfully navigated. And just to have having a feel for what it's like to be in the shoes of a general counsel, and what can go right and wrong for that person in that role. I think that's one of the key reasons that, for the right case, that's I think useful.
What do you recommend to avoid? How do you avoid bad outcomes at mediations?
Well, there are a myriad of pitfalls, and a non-exhaustive list would include arrogance, overconfidence, failing to see the case and the situation from the side of the adversary, not necessarily to agree with them or just to capitulate to them, but just to at least go through the mental exercise of why is the other side perhaps taking this fanciful position, or why are they bringing this frivolous case, or why do they think that their case has merit? So at least go through the exercise of thinking about that before you dismiss where they're coming from. I don't know, Mark, what do you think?
Right.
No, I agree with that. I will tell quickly, in stepping into different company roles as GC, where I was assessing the disputes I inherited. there were many cases where everything made perfect sense. I'm not going to change anything. There were some where I said, well, why don't we try some direct dialogue or mediation? And more than once with prominent firms, I heard stories about how outrageous the people on the other side had been. And I'm not doubting the stories are true. I'm also not doubting that we probably didn't contribute to it, the adversarial nature ourselves. But more than once I said, well, I still want to try because I think they are misinformed. I want them to be informed. And if also find out there's something I'm missing. And again, no, they're not going to be reasonable. Guess what? We did it anyway. I politely try to suppress this notion they're evil. It's like, no, we're trying to resolve a dispute. We want to show them we don't have horns. If we have good reason to change their minds, let's show it to them. And all the flotsam and jetsam about how bad they've been so far, it's like, set that aside. Let's see what we can do here today. It always makes things better. Not to say every time we then go and mediate, the case resolves immediately, but we're better informed, they're better informed. We can scale what we do next, and that's really, really important. And again, I don't mean to say this is outside counsel has to do something different, plaintiffs counsel do something different. We all own these kinds of problems, including the in-house people who may not have made clear what their real objectives are. So outside counsel, job to ask, and our job is to be really clear, including my message. If we're not going the direction you think we should, you're not going to hurt our feelings by saying that. I'd rather have that now than later. And give them the freedom to give us, direct us in a different course. And lastly, one of my mantras on that front is to the arrogance point. I always politely say, it's not helping me. It's not helping me help you. It's definitely not going to help them change to your position. And oh, by the way, we're all doing our job here. Plaintiffs' counsel is doing their job. Defense counsel is doing their job. Let's get beyond that and talk about what we can do to settle the case.
So one other point that I would make, and this is more stated in the positive than as a pitfall, but mediation and the litigation process and the interaction between in-house counsel and outside counsel, it's a team game. So for the best result in mediation or in the litigation itself is the best chance for a good outcome is good teamwork and giving each participant what they need to do their job effectively, and to communicate early and often to make sure that you're aligned and you're doing things to help each other and not working at cross purposes or failing to do something or deliver something that the other side that your partner needs.
Right. And I know we just have a few more minutes, so kind of along the theme of teamwork and partnership that both of you have mentioned. Kind of in closing, what advice do you have for GCs and in-house teams that will help improve not just the prospects of it, successful mediation isn't just resolving the dispute and settling the case, but also having the client, be satisfied with the result, especially, the broader perspective of the GC. So Ed, your thoughts, and then Mark in closing.
I think possibly involve your internal constituents in the selection of the mediator, especially for bigger cases. For smaller cases, they're probably not going to want to be bothered with that in larger companies, but keep them advised on what you're doing, and just making sure that the in-house counsel is communicating internally and externally throughout, and keep an eye on when things change, and make with the case and with things inside the mediation. Go there with your eyes and ears wide open and see what you can learn. A successful mediation might not always mean settling the case, although that's what we are striving for when we go to mediation a lot of the times, but maybe you'll learn something about the case and your case that will be useful down the line.
Thanks. And Mark, your thoughts?
So as I used to tell my legal teams, the number doesn't matter. How people respond to the number is what matters. So if we're doing our job well as in-house teams, but obviously you'd say the same thing outside counsel, we need to diagnose this correctly from day one. If anything is shifting, we need to talk about how it's shifting and why it's shifting, not to blame, but just to better communicate internally. Sometimes bad news is something people don't want to convey, so they sit on it. And outside counsel, do not ever let that happen because, surprises are really, really bad. So again, if we've done our job well, as in-house teams and outside teams, we've diagnosed it properly by doing the direct conversation from the other side, by updating people about anything that comes out of the blue. And then we get to a point where people should say, under the circumstances, that's a good outcome. If they're saying, oh my God, that's awful, whether it's settling this small case for small dollars. I've settled cases for large sums of money in my Jersey days where people said, that's great under the circumstances. It's our job, the in-house people, to communicate internally where the expectation should be, not to delay. Not delay the difficult conversations. Ideally, you avoid them altogether by doing the tire kicking really thoroughly from the beginning. Tell your outside partners, you need to help me, because if it goes badly, we're going to have some difficult conversations. Not to be mean, but just this is all avoidable if you're doing the hard work up front or you're continuing to update and avoiding surprises.
So I would just say two quick things along those lines. Number one, everything you said, super important, super critical. But in terms of practicalities, the outside lawyer needs to make sure who is going to inform whom, and reiterate it needs to be done almost immediately, and make sure that you follow up to make sure that the in-house lawyer, especially if it's someone who is maybe a little less experienced, or maybe hasn't handled litigation as much before, or maybe it's their first one, just make sure that it gets communicated immediately and fully and properly.
Great. Well, about 60 seconds left. Any closing thoughts? Ed?
No, I
Mark?
thought that was a great conversation. And as we prepare for this, as Ed and Judge Feffer know, we could go for hours on these topics based upon real life situations we've seen, but they're learning opportunities, and hopefully some of this dialogue will help people think differently going forward.
Absolutely. Ed, anything in closing?
No, just thank you for the opportunity. I enjoyed the discussion. I actually learned a few things myself.
Yeah.
Absolutely.
Hey, Katie, I think we're right at almost at 1. I have not been looking at the questions or the chat. Are there any items it's worth addressing now?
Yes, thank you, everybody. As a note, we are right at the 1 o'clock mark. If you do have to leave to head off to any afternoon engagements, please feel free to do so, and you will.
And I've been following. I think we covered a lot of it.
Yeah.
But obviously, I know there are a lot of questions about sharing briefs and all that. Again, I think everyone here, myself and Ed and Mark, we all do a pre-mediation phone call, and so raise these issues. It's helpful for me when I have litigation counsel saying, I'm just counsel in this case, the GC will also be there. The pre-mediation phone call is a great way to let your neutral know the dynamics of, of all these things we've been discussing. And certainly I think all of us would prefer that the parties exchange briefs. I think we've hit on that quite extensively, like prepare. Don't leave it for last minute. Certainly exchange the briefs. And again, when you're dealing with especially with a corporate entity or whatnot, give the other side time to think about it, because they might have been hearing the message of everything's great, it's defensible, and you're on the plaintiff side. You really need to educate them and get everyone involved who needs to be involved. But certainly all of these dynamics should be raised. So when your mediator calls you, as Ed will, as Mark will, as I will, let the mediator know these dynamics. And if there's anything the mediator can do beforehand to help move things along, that would be fantastic. So excellent discussion. I learned a lot from both of you. I appreciate you both being here.
No,
Yes, thank you all
great.
so very much. I really appreciate you participating in this program and sharing your thoughts. Great conversation.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, So did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.